Okay, welcome everybody. Hello and welcome to our discussion of the new U.S. patent policy, a look ahead. Today we've got a panel of really impressive business chiefs and thought leaders who are going to help us understand the real world impact of the new U.S. draft policy. A word on that new U.S. draft policy. It was issued in December by the Department of Justice, the Patent and Trademark Office, and the National Institute for Standards and Technology. And its subject is an issue that has been front and center at the intersection of intellectual property law and antitrust law for years. The question of standards essential patents, licensing, and injunctive relief. The draft policy statement discusses the scope of remedies available to the holders of standards essential patents who have agreed to license those patents on fair and or reasonable and non-discriminatory bases, so-called FRAND or RAND terms. And it articulates limits on the exclusionary remedies for those FRAND-burdened standard essential patents. The agencies had a public comment period following the issuance of that draft policy, and they've received some 150 comments. They are reviewing those comments now, and we are awaiting the agency's next steps. A very quick word on the important backstory of this policy before we dive in to our panel. The issue started, the policies, the written policies from these two or three agencies started in 2013 when the Justice Department and the PTO issued a policy statement emphasizing that injunctions for standards essential patents could harm competition and by allowing standard essential patent holders to get royalties higher than they could otherwise command. In 2019, the DOJ, the Patent Office, and NIST issued a statement that cast doubt on some of the key propositions in that prior policy. And in December of last year, the Justice Department, along with its sister agencies, DOJ and NIST, issued a policy that's now being described as a return to earlier practice and possibly an earlier consensus. To unpack all of this for us, we have an amazing array of panelists. Let me introduce them now. Emily Hart is the Chief Operating Officer of Motion Mobs, a woman-owned, woman-founded software developing and consulting firm. Among the firm's projects is the development of Alabama's COVID-19 exposure notification app. And before joining Motion Mobs in 2014, Emily worked in marketing for a major consumer electronics innovator. Alex Moss is the executive director of the Public Interest Patent Law Institute. She's also a special advisor for the Electronic Frontier Foundation. She works to ensure in these roles that the patent system promotes innovation and access to technology. She was previously a patent litigator and clerked for Judge Dyke in the U.S. Court of Appeals for the Federal Circuit. Jim Oliphant is Managing Director and Litigation Department Lead for American Honda's Intellectual Property Unit. He leads Honda's IP attorneys throughout North America and advises the company on standard essential patent issues. Jim draws on his deep expertise as an IP litigator as he guides Honda through these very challenging issues. And Professor Tim Simcoe is an associate professor in the Strategy and Innovation Department at Boston University's Questrom School of Business. He's also a research associate at the National Bureau of Economic Research and a faculty director at the BU Technology Policy Research Initiative. He served as a senior economist on President Obama's Council of Economic Advisors, and his research focuses on innovation, industry standards, intellectual property, and technology policy. For my part, I'm Gail Levine. I co-lead Mayer Brown's Global Antitrust and Competition practice. I joined Mayer Brown from the Bureau of Competition of the Federal Trade Commission, where I was a deputy director. I served as head of regulatory affairs for Uber, and as a vice president at Verizon, I handled antitrust and intellectual property issues like the ones we're going to be talking about today. I've just joined Mayor Brown for my second tour of duty at the Federal Trade Commission. In my first tour of duty at the FTC, I was an advisor to the chairman where I advised her on issues just like these, antitrust and IP issues. A quick note on logistics before we dive in today. You'll see a button at the bottom of your screen labeled Q&A. If you have a question for any of our panelists, please enter it in that box. We'll save some time at the end of our discussion to address the questions you have. You'll also see a chat button. We're not going to be monitoring that as closely. So if you've got a question, please put it in the Q&A, not in the chat. All right, with those preliminaries out of the way, I am delighted to jump in to ask the hard questions of our panelists. I'd like to start by going around to each of you and asking you, what's the real world effect that you see behind from the positions in the 2001 draft policy from the three agencies? Maybe, Jim, let me start with you. What do you suspect are the real world effects of these policies?
Sure, thanks, Gail. For Honda, certainly the real world effects are just that. They are very real. We are always looking to support a balanced IP approach. We, as at Honda, are both innovators and implementers, right? So we have many patents. We also manufacture and have to use others' patents in order to build our products. And so at the end of the day, what we want is to have a fair and balanced approach. One of the issues that we're looking at in terms of having that balance is to make sure that there isn't undue weight given to one side or the other when it comes to negotiations on standard essential patents. And at the end of the day, we don't want to be in a situation where we are having to overpay for the right to use a particular technology out of fear that we would be held hostage to an injunction, for example, that would be significant for our operations. Obviously, if you have an injunction in place, we can't sell products. And yes, that hurts our sales, of course, but it hurts all of our operations, including all of our associates. I mean, I don't think people are aware just how much manufacturing we do in the US. People think of Honda as a Japanese company. We have large operations here in this country. We have over 30,000 associates, many of them who are in the business of manufacturing here in the US. We've got 3 auto plants in Indiana, Ohio, and Alabama. We manufacture airplanes in North Carolina. And if there's an injunction in place because of the negotiations over certain SEPs, basically they're not working, right? And not just our own associates, but we purchased from over 600 suppliers in the US. Last year alone, we purchased over $30 billion worth of parts from those suppliers. And they would not be able to work either, at least to supply us if we were put in a situation where you have an injunction. So with all of that in mind, I mean, it's again, we're looking for something that is balanced. And when you think about that, think about sometimes some of the unfairness that can come out of this. So you might have a single component that is at issue that we are negotiating with a particular SEP owner, and that single component might comprise one of hundreds, if not over 1,000 components that go into each of our vehicles, right? And the inability to sell or manufacture a vehicle because of that single component, you can see just how much leverage an SEP owner could have if they could say convince a court or any tribunal to issue an injunction. And so it's trying to have a balanced approach where IP owners are compensated fairly, but not to the point where they are able to leverage that type of situation to extract licensing fees that in our minds would be in excess of what is otherwise deserved. So from our perspective, definitely real world implications that we think can be avoided by having a balanced approach.
And can I just ask you a quick follow-up question on that? Can you sort of help us understand whether and how the draft IP policy, the one issued in December, achieves that balance?
Well, I think it starts to walk back a little bit this idea that injunctions should be a part of the a remedy that should be implemented through whenever some type of, or the negotiations, SEP negotiations might be stalled. And I don't think that should be the case. I think in very, very limited circumstances should it ever come into place, but not because of stalled negotiations. At the end of the day, I think that it's all about what is the appropriate compensation. The SEP owners who've declared their patents have already agreed to provide their technology to people who are willing to take licenses. And it's in exchange, they get a large licensing pool for which they will get fair, reasonable, and non-discriminatory terms in terms of their rates. And so it's really all about what is the appropriate compensation. I think that the draft statement does a good job in terms of trying to reposition the appropriateness of an injunction. There are other things about the draft statement that I think I hope are addressed. I don't think it addresses all of my personal concerns or issues, but I do think it does a very good job in terms of rebalancing the fairness to both IP owners and implementers.
Terrific. Thanks so much. Emily, do you want to take a stab at the sort of same question? What are the real world effects of this new policy should it become
Certainly.
the official policy?
Thank you, Gail. So as a software developer in the small business sector, we rely on a healthy ecosystem where we have consistent access to what I would consider the building blocks that fuel innovation. And so whether we're developing for a specific platform or for maximum market reach, the products that we're developing always include the use of both hardware and software standards that most people take for granted. And because small businesses operate from limited resources, including time and finances, businesses like ourselves and our clients need the certainty, like this policy provides, that we have fair access to SEPs and that infringement claims that may happen further up the food chain don't have the possibility of shutting down businesses like our own. And most small businesses don't have in-house legal counsel or endless legal budgets. One vague or malicious threat from an SEP holder can pressure a small business into bankruptcy or closure because they don't know how to respond. I'm very, very grateful that this particular draft of the policy has added specific language around the concept of reasonable, so that when negotiations need to happen, both parties need to be transparent about what they're asking for, what is on the table, and what agreement needs to be come to. This helps empower small businesses to claim their seat at the table and not be needlessly swept out of the way by a very, very large company. I'd also add, nobody forces a patent owner to put that patent into a standard. That's something that they do because they want to participate in it. It's financially beneficial to them and then to those innovators who will use that patent. And so as a result, it feels very advantageous for the large companies who know that they have the power behind them to threaten a smaller company to pay more than they really should for use of that SEP, simply because that smaller company doesn't know any better and doesn't have the resources to push back. So all in all, I'm very grateful for how balanced this policy reads and those additional protections that are covering those who may be newer to the market.
That's a terrific explication of of your special position in the small business as a small business mover and shaker. So thank you for that perspective. Alex, can I turn it to you?
Sure. So looking at the other side of what Jim and Emily talked about, which is, what's the effect on this on people who buy and use technology, is really what's at stake is reliable and affordable access to the enormous range of products and services that incorporate standards. It's really practically almost the interconnected world we have. Standards are the backbone of that. So even all of us here right now accessing this video conference are relying on standards. And the main issue that the DOJ draft statement addresses is how full-throated of an endorsement or opposition will the government provide for standard essential patent owners to obtain injunctions or court orders that block access to the products. And for consumers, that can mean products are taken off shelves, that functionality is taken away, that the components that the suppliers need are seized at the border. And this can apply to your cell phone, to heart monitors, to assistive devices, to cars. It's increasing range of products and services that we depend on. And as Emily mentioned, what is at stake not only is getting this court order that blocks access, but can SEP owners use that threat, the threat of seeking an injunction, in particular seeking an injunction before a court actually rules on whether the products infringe the patents or not. And this threat itself imposes an enormous amount of pressure and gives SEP owners the ability to demand higher licensing fees than really are fair, reasonable, or non-discriminatory. And so for consumers, the other side of that is higher prices or fewer products on the shelf. And at an aggregate level, it's really a flow of money from the companies that make things and develop products and sell them to companies that don't make products and don't sell them. And so the last administration put a very heavy thumb, really more like a hand or a whole body weight in favor of SEP owners being free to seek and obtain injunctions as they please. And that's despite the fact that in exchange for participating in standard setting, they committed to license their patents on free, reasonable, and non-discriminatory terms. That means they agreed to accept money for a license to their patents instead of seeking an injunction order. And typically the idea behind giving patent owners the right to injunctions is that if they're going to make their own products, that they should be the ones that are free to use their own patented technology in the marketplace. It's not supposed to be a bullying stick that lets patent owners demand more. That's really using the cost of fighting an injunction. It's really using the cost of litigation to bulk up the licensing rate rather than the value of their technology. And so what this draft does is it really takes that extra heavy weight off of the scales in favor of injunctive relief. It's a move towards a balance that we had before. I think as others have mentioned, the draft doesn't do everything to really make this. I would say it still puts a scale or weight, a bit on the scales in favor of SEP owners. And it's important to remember that the purpose of standardization is actually to benefit the public, to make sure that we can all use devices that can communicate with each other and on the same networks, whoever makes them. And really the focus should be what benefits the public, because as Emily's mentioned, SEP owners are getting a huge benefit by having their technology incorporated into a standard, and by being able to get injunction relief whenever they please. It really entitles them to a windfall at the public's expense.
Yeah, and Gail, if I can
please
jump on top of something that Alex just said too, it's the impact to the consumer is also a very real issue if an injunction is in place that prevents an implementer or a manufacturer from being able to sell their products. And it's a very current example illustrates that. right now, if anybody, just close to my industry, if anybody's tried to purchase a new vehicle recently, they will tell you how difficult it is because of the chip supply shortage, right? That every automotive OEM is experiencing. And so that what has happened is caused the prices to rise such that you might not get as good of a deal with the dealer. It may be that a used car now costs a lot more than otherwise would, because again, there's demand because there aren't as many vehicles being built out there. And so imagine a situation where whether it's Honda or any other automotive OEM is no longer able to manufacture the same amount of vehicles they otherwise plan to. That can exacerbate that type of supply issues that will only cause consumers to end up paying more. And for what? It's again, at the end of the day, it's really about compensating IP owners at fair and reasonable rates. And that's something that can be achieved without essentially punishing the consumers who are looking to ultimately buy these products.
That makes a lot of sense. Tim, do you want to add to that with your thoughts on the real world effects of the ideas behind the draft policy?
Sure. Let me try to frame this a little more broadly in the following way. I think it's maybe useful to think about real world effects at two levels, right? So first level is just the policy speaks about how easy is it to get access to an injunction or a prohibitive order or an exclusion order, and also a bit about how courts might look at licensing negotiation behavior and trying to understand if parties are negotiating in good faith. And that has one set of real world effects on how money is allocated between licensors and licensees. Okay. And I actually don't think there's a lot of disagreement over that. Sort of it's very clear that if you can easily get access to injunction or prohibitive order or exclusion, you're going to, it favors the licensor. That's what we've been hearing about. There's a second layer of real world effects where, sort of the expected royalties feed into decisions about R&D investment by both licensors and implementers, about investments in other parts of products that implement standards, into decisions about how many standards are supplied, participating, whether those standards are open or closed, about whether I'm going to outsource specific parts of my products, specific components, or keep that manufacturing in-house. Those kinds of more strategic decisions, I would say both sides in this debate have many stories, right? You'll hear from the licensors, if you take away access to exclusionary orders and injunctions, I won't do the R&D, I won't show up at the standard setting organization. And we hear here, right, sort of it can feel, access to the injunctions can feel very unfair to someone who's, having an entire product or product line taken off the market for a tiny, a patent that relates to a tiny component, or for a small business, facing an existential threat. As an economist who's supposed to try and aggregate all those things up, I'm just going to say, we don't have good evidence on those bigger strategic effects. It is very hard to understand, no matter how compelling the stories told by either side, how these things aggregate up, because we don't have great natural experiments. I think maybe the best experiment that we have that sort of speaks to, but is not directly on point here, is in the US in 2003, we got the eBay decision. Okay, eBay made it so that courts could weigh a number of factors and decide whether in a particular case it was appropriate to grant an injunction because of irreparable harm, or in cases that I think are like what we're talking about here, where there's a lot of evidence that there's already been an agreement to license where monetary compensation would be an appropriate form of relief. What did you see after eBay? Well, American innovation did not collapse. I wrote a paper about this where we looked for evidence of disparate impacts of eBay. It's just not the case that we've seen slower investment in R&D or less venture capital or fewer patents or anything really at the aggregate level, comparing, say, IT sectors to life sciences in the US after eBay. So I think there's, reason to feel like we can have innovation without, sort of easy or automatic access to injunction. And so my own view is that in this setting, kind of the principles favor the kinds of arguments we've been hearing here, right? When a firm decides as a choice to try and put its patented technology into a standard, part of what happens is it gets antitrust permission to cooperate with firms that it would ordinarily compete with in markets for technology. And in return for the permission to cooperate, the benefits of the standard are not appropriated by the patent holder, right? The patent holder is entitled to recover something that is commensurate with the value added by its particular patented piece of the standard. And we just know that, sort of easy access to injunctions or exclusion are going to reward you not just for your piece, but for the whole standard, investments, and even investments in products that are unrelated to the standard. And so it's nice, I think, to see the new policy step in and try to articulate those principles more clearly.
And do you think that the new policy has struck the right balance given the state of the empirical knowledge we have today?
Yeah, I think the policy is quite even-handed and sort of a return to an appropriate balance, sort of that's trying to both provide useful guidance about what looks like good faith negotiation from both sides, but also just articulates the principle that until you've got an adjudicated FRAND rate, we shouldn't be taking products off the market, sort of in giving, extreme leverage in bargaining situations to one side.
Got it. Hey, let's take a step back here. We've been talking about the policy and its real-world effects. Let's take a step back to talk about sort of what's at stake here and why this conversation matters for not just today, but for the future. Alex, can I get your thoughts on the importance of standards and the importance of standards in industries today and in industries to come? This used to be, this debate had one of its first iterations in the telecom sector. And I know you have views, Alex, on where we will see this debate go in terms of next industries. So can you speak to a little bit to the future of the markets where this will be newly relevant?
Sure. Well, standards are really the backbone of this interconnected world, or the Internet of Things that people talk about. They're what they're what allow devices to communicate with each other. Of course, there are many different kinds of standards, but in this context, we're generally talking about communication standards. And what part of the value comes from the technology, but it's also important to recognize that a lot of the value comes from standardization. If you could build a tool that would allow lightning fast communication on, but if you're the only one with that technology, how valuable is that to you? Is that really going to be what the network you're going to be on? So it's important to recognize that in a way, everybody who uses the standard actually contributes to its value. And we already see them in more and more devices, cell phones and laptops we talk about, but they are in anytime you see a device described as smart, it's probably incorporating a standard. So smartwatches, people have more and more health devices that are connected, and so heart monitors, automatically transmit data to doctors. Emily has mentioned or worked on the apps that were involved in COVID. Anytime if you went and got a vaccine and someone was using their tablet to transmit that data, they were relying on a standard. And we now see connectivity in burglar alarms. It's built into cars as standard. They're in power meters. They're in refrigerators. And so it's already touching more and more aspects of our daily lives. I think the two places you're going to see that continue is just that connectivity is going to embed deeper and deeper into our lives. I wouldn't have thought of refrigerators 5 to 10 years ago, but that's becoming increasingly standard. And I tend to think that the biggest place where this is going to become standard is really in healthcare and healthcare devices and spaces. I think that COVID and the need to have remote healthcare has been that's something that before COVID people, there was almost no market for telehealth products and services. And I think now there never won't be a market for those. So I think that health, I think probably in 10 or 12, 20 years, healthcare and software aren't going to seem like different industries anymore. So that's really what one of the areas I think I see the biggest role for standards to play an even more essential aspect in our lives, and the other being consumer products at home. And I think it's also worth noting that even existing products are probably going to be used in more and more ways that are essential. So computers and cell phones we've had for a long time, but I think particularly with COVID in terms of education and jobs, that we're seeing these become even more and more integral. So the role standards play in our lives, I think, can't be underestimated today, and is only going to increase tomorrow.
Right. So it sounds like the debate is becoming more relevant to more aspects of our lives than ever. Emily, do you want to give us the small business perspective on the relevance of this debate going forward for high tech and small business in the Internet of Things?
Would be happy to. So I think of a lot of the innovators in the Internet of Things space as really your classic tinkerers. These are people who see components and say, I can put these together. I can solve a problem with it. I can create something new. And realistically, whether those parts are either being purchased wholesale or we're looking at consumer purchase devices that are then pieced together, there's an assumption that the components are appropriately licensed. And when somebody looks at how am I going to grow this, how am I going to solve more problems with it, the use of that chip, of a connector, of some kind of telecommunications doesn't change value based on the application that that company then develops to put on it. So this gets a little bit into whether we're looking at end user licensing versus per component licensing. But I feel very strongly that it should be incredibly clear cut for somebody who is looking to either purchase or develop hardware. That hardware does exactly what it says it was going to. And then what I, as an innovator, choose to do with it is up to me. If I want to put a whole bunch of pieces together, I'll purchase each one of those pieces, put them together, and maybe change the world. Maybe not. But as we see this move into the healthcare space specifically, we're actually talking about saving lives through standardized essential patents. And at the end of the day, honestly, I feel very strongly that as important as that chip is, it's just a chip. And we shouldn't be able to allow the SEP holder in that case say, no, you can't save lives with the innovation you've applied to my chip. I want more money to it. Oversimplification there. But I feel like at the end of the day, we want to make sure that small businesses or large businesses have the flexibility to use these components realistically to change the world.
Thanks so much. I want to pick up on one of the nuggets of wisdom you had in your answer about the end user versus components debates. Jim, I know you have some thoughts on this. Can you speak, Jim, for us about that end user versus component level licensing debate and how that intersects with the draft policy that was issued last month, a couple of months ago?
Yeah, I think that's the one area I mentioned earlier, that I think there are things in the draft policy statement that that don't address all the concerns. I think this is one of them. I think, frankly, that when you're talking about SEPs, and we've talked about sort of what the bargain is, right, in terms of being able to you as an SEP holder have committed to allowing your patent, your technology to be practiced in exchange for a larger licensing pool, in exchange for FRAND rates. But at the end of the day, everyone should be allowed to take a license, right? It shouldn't be just, oh, well, we're only going to give I'll give this permission to end users or the OEM level, as opposed to a supplier of a specific component that's actually using or implementing the standardized technology, right? So the fact of the matter is that at the end of the day, everybody should be able to take a license. Standards are practiced by many entities. They're not just practiced by OEMs. In fact, it's typically, certainly in my industry, we end up taking a lot of the technology that is developed by suppliers up the supply chain that we ultimately incorporate into our vehicles. But we're not the experts, right? It's our suppliers. They're the ones who should be allowed to take licenses so that they can continue, as Emily mentioned, to innovate, right? They're the ones who are figuring out what is it that we can do with this technology in a way that others will want to purchase from us. And that will allow them to thrive. That will allow them to innovate. And let me give you an actual example of what we deal with, just to kind of put this in real terms. So I don't think that we should exclude innovators from being able to take SEPs. So for example, at the OEM level, automotive OEM level, we will end up buying a telematic control unit, or TCU, from what we call our tier 1 supplier. That supplier in turn will purchase a network access device from another supplier. That network access device supplier will purchase the chip that goes into the NAD or the NAD from yet another supplier. So from our perspective, from Honda's perspective, we're 3 levels removed from where the innovation for that particular technology, whether it's wireless technology or connectivity, is actually happening, right? So it's that chip manufacturer who has that specialty. It's that chip manufacturer who understands exactly what the value of the particular patent that's at issue gives to that particular technology, right? They understand it, they understand the value, they understand what is fair and what is reasonable. And basically there is, when you're dealing directly with those innovators for that particular technology, there's no more what we like to call information asymmetry, right? The right people are talking to each other to figure out at the end of the day, what is fair compensation, right? And in that way, you're able to also limit the possibility or the potential of paying for the value of the standardization itself, which has been mentioned already earlier, I think by Emily. And so that way you avoid that overpayment, but yet still paying fair terms to whatever value that patent has added to the standard. And I think at the end of the day, it's ultimately a good thing.
All right, so thank you for that. And I want to go to another question that we've also seen in a lot of the comments, the comments that the agency has gotten since releasing this draft patent. In addition to this question about the supply chain, there's also been a lot of noise or conversation in the comments about whether the IATC exclusion order should be expressly encompassed by the draft or in the final IP order that the agency's issues. Jim, do you want to address that? Or Tim?
Yeah, I'll take that on first. I don't see how you can't address it as well. If at the end of the day, we've been talking about the leverage that an entity can have by having the right to have an injunction, right? And that should be addressed. But if they're able to leverage that or get that same leverage through another forum, in this case, the ITC, then you're really basically just forcing everybody to run over to the ITC to be able to get that same leverage, because at the end of the day, that's what some entities might be trying to do in order to get significantly higher compensation that is not otherwise due. And so I think by not addressing the ITC issue, you are creating a significant loophole that will be exploited. And at the end of the day, we'll still be talking about the same issues because obviously they'll be able to try to seek that leverage in that forum.
Tim, do you want to speak to that issue? And I also would like to ask you, Tim, to address the empirical research you've been doing on the related area, the continuations practice area.
Sure. I want to sort of address both of the things Jim just mentioned. First on the IATC, look, I'm sure that the IATC takes its obligation to consider public interest seriously. However, it's a real problem, right? That we have two venues for litigating patents, and one of which only has access to injunctive like remedies. It creates a problem. So my hope is that the policy statement is understood, if not explicitly referencing, ITC as a venue. On the licensing level debate, this is stepping maybe outside the draft policy statement a little, but I think it's worth saying a couple things. One is, I just want to recommend a paper by George Contreras on the history of FRAND commitments that sort of speaks to the historical intent, which I think is pretty clear about. These were meant to be a commitment to license to everyone who needs a license. And there's good reasons for it. I think the leading one is, what do you do if there's no commitment to license everyone? What do you do about firms that refuse to license direct competitors? I think statements like, don't worry, your customer has to take a license from us, but in that secret license, we'll be really fair to you. We shouldn't interpret that as a royalty-free license. It just doesn't, And so, and then lastly, I think there's an emerging consensus among economists on that issue that, no matter what level of the chain you license at, it shouldn't affect the price. Right, there's a long tradition of figuring out where prices come from in economics. Kind of boils down to demand, cost, competition. In that list, nowhere does level of the supply chain appear. But there's a bunch of practical reasons why sometimes licensors want to go downstream, right? Like part of it is if I can get an injunction against a car, that gives me more leverage than if I can get an injunction against a chip. Part of it is the price I'm seeking looks very small compared to the price of a car as opposed to the price of a chip. And so we should just be aware of those kinds of psychological and anchoring biases in price setting by courts that might lead to, sort of the view that it's just reality that somehow prices are higher downstream. So far, I don't want to talk forever. I've kind of avoided your third question, Gail. I've done some research on continuations, and so I think another interesting aspect of the whole debate over SEPs is where they come from. And I guess the headline finding from this work that I do with Cesare Righi is that more than half of the US standard essential patents that are explicitly declared to sort of major SSOs have a filing date that is after the date when the relevant standard is published, right? So how could that be, right? Like, how can you get a patent on a standard like that's already published? Well, there's just really widespread use of continuations, which is kind of a tool you can use as a patent prosecutor to sort of file an application and then wait and draft your claims after you know what's already in the standard. And we show a number of things related to that, but I think that the importance of it just sort of speaks to how SEPs have become a very attractive business opportunity, and that sort of promotes trying to game the patent system in ways, right? Sort of delay. We can debate the extent to which it's legitimate or illegitimate gaming, but it's kind of, it looks like let's wait and try to sort of get patents on the stuff that we know is already there, as opposed to the narrative you hear about like seminal invention, we've got to stick it into the standard.
Well, thank you very much for that. Let me shift gears very briefly from substance to process and talk about timing. The draft IP report issued in December. Comments were due after an extension here this month in February, and the agencies are now digesting the insights from the comments. Emily, can you give us your thoughts about what the agencies should be thinking about as they think about how quickly they need to advance to the next step of this process of moving from draft to their ultimate next move?
Of course. Speaking selfishly, as a member of small business myself, I see that without this policy, we have very little power. And there's very little to back us up should there be any kind of threat made against a small business, whether it's somebody who's in the Internet of Things, if they're in health tech, or if they're just a software developer. And I see it as being very important to supporting small business and small innovators who are looking to get into the market, to engage in a competitive market. They need the protections of policies like this to make sure that when they go to the table with somebody who has a lot of weight behind them, that it's an even playing field and that they know that the negotiations are going to be reasonable, they are going to be fair, and they can't be taken advantage of. So I see this as something that we need to implement as quickly as we can.
Great. Any other thoughts on that question before we move to another critical comment we saw in the commentary that was issued, that was submitted to the agencies during the commentary period? Well, let me shift to that then. We've seen in the comments, we've seen a lot of commentary on a number of grounds, and one of them criticizes the IP draft on a kind of foreign policy grounds, noting that some of the some of the allegedly systemic holdout practices happen overseas, and that urging the agencies to tune into that is an issue. I'd like to get the thoughts of this panel on questions like that. Alex, would you like to address that one?
Sure. That criticism is misinformation, and it is based on ignoring really the fundamentals of the patent system. U.S. patents have the ability to stop people from making, using, selling, or importing things in the United States. They have no force outside of the United States. If companies in China are not licensing U.S. patents, it's because U.S. patents have no power in China. So the idea that the DOJ's policy is going to have any impact on the conduct of companies in China is completely fallacious. However, and even worse, is it's really the opposite is true. U.S. patents, as Emily's talked a lot about on small businesses, they have the power to shut small businesses down, to end competition, to thwart whole economies in the U.S. They have the power to stop competition in the U.S. and put U.S. companies out of businesses. So the concern should be for U.S. companies, and also underlying that criticism is a false assumption that the owners of U.S. patents are necessarily U.S. companies. In fact, more than half of U.S. patents are being granted to non-U.S. companies, which means that making it easier for the owners of U.S. patents to get injunctions disproportionately empowers non-U.S. companies to restrict activity by U.S. companies. And one example of that is Huawei, which has been shut out of a lot of U.S. markets, owns a lot of U.S. patents and is using them, asserting them against U.S. companies to try to shut down their activities in the U.S. So that criticism is not only misplaced, but fundamentally false, and really hides and obscures the real concern for U.S. companies and what the easy access to injunctions does to hurt them.
Thank you for that. Other thoughts on that issue? Maybe we'll take a question from the floor then, the virtual floor. We've gotten a question in our Q&A box, and here it is. And I'll throw this out to anyone on the panel who wishes to ask. In your opinion, will changing the ability to seek a preliminary injunction discourage SEP owners from participating in the SEP process? In other words, will an unintended consequence be that you face such patent holders in court anyway? Thoughts from the panel on a question like that?
It's a good segue back to the research I mentioned earlier about continuation practice, right? So if it's the case that a lot of SEPs aren't even filed, they're filed by companies that are participating in the standard setting process, but waiting until the standard is published to sort of then write the claims, that kind of suggests that they're not going to abandon the process, right? Like it's actually hard to get the patent to be essential if you don't know, if you're not there and part of the standards process. So I think honestly, there's two issues here. One is firms that don't participate, you can't avoid the fact, some of them will patent and they may have patents that turn out to be essential. And then, you would litigate them the way you would litigate any ordinary patent, or you would license them, negotiate an agreement. The other piece about like, do they participate or not? I would say the evidence that strengthening patent policies or changing patent policies leads firms to quit standard setting really is non-existent. And the micro evidence from patent prosecution that I was just describing suggests that firms that are really interested in building a portfolio of SEPs are going to want to participate in the standard setting process so they know what direction the standard is moving in. So I don't think it's a big issue.
Yeah, I don't think it should be an issue either. Again, the goal of SEP owners is not to exclude others from practicing their technology. It's the exact opposite. They want people to use it. They want their technology to be incorporated into a standard, which at the end of the day creates a very large patent pool for them to be able to license their patents. And at the end of the day, they're getting their rates, FRAN rates, as a result of that. It's not a situation where I come up with an invention, I want to use my right to exclude others so that I can practice it for my limited temporal monopoly, and then and position myself in a way that is beneficial to me. That's not what's going on with SEPs, right? And so at the end of the day, what an SEP owner is looking for is not to exclude somebody from practicing it, but is to get FRAN rates. And there are ways to do that. Obviously, the hope is that it happens through negotiations, private negotiations. And if for some reason that cannot come to, a deal cannot come to fruition in terms of what is FRAN, well, then we have the courts that are in place or neutral arbitrators who can ultimately make that decision. And then the party, one party is going to pay and the other party is going to receive in terms of what is fair. So it should have no impact in terms of parties participating in the standardization process, because at the end of the day, they should still be able to obtain the fair compensation that they deserve.
Let me ask you, Jim, about another issue that we see in the draft IP report. There's a lot of conversation in the draft IP report about negotiations behavior as part of a discussion about remedies. Does that feel appropriate to you? Tell us what your thoughts are on that.
Yeah, I don't think it's appropriate. I think there should be a decoupling between licensing behaviors or negotiation behaviors and what the appropriate remedy in this case, whether it's an injunction or not, should apply. I think when you're talking about licensing behaviors, negotiation behaviors, I think it's way too subjective. I think what are you going to base it on in terms of whether somebody is being an unwilling licensee, for example, and that ultimately might lead to support for an injunction. I do think that those two things have to be decoupled. Look, if at the end of the day you have a situation where I am ordered by a court, hey, you need to pay X amount per item as part of the FRAN rate, and I refuse to do it, okay, then maybe an injunction makes sense. But that now you're talking about something that's much more objective rather than subjective in terms of when something like that should happen. But when you're talking about licensing or negotiation behaviors, I just think it's way too subjective. Somebody might think a particular rate is FRAN. I might disagree. I might think that that a particular patent is not essential to the standard. I might think that your particular patent might be invalid. Should my behavior in negotiations based on those positions be used against me to otherwise support an injunction? I don't think so. And so I definitely think that there should be a decoupling of those items.
Alex, do you have some thoughts on this?
I agree with Jim said, but I almost think that it would be worth, clarifying that by challenging whether a patent is essential or invalid, that is not unwilling licensee behavior.
Agreed.
And worth noting that one company, when that happens, there are external benefits to the public. If an invalid patent is being asserted and used to drive up costs, everybody else benefits. It's really like a gift to the licensees, competitors, for them to make that challenge. And our more than half of patents that are granted end up being proven invalid, or maybe over 40% are proven invalid when they are challenged. And one of the premises of our patent system is actually that it's very hard to tell early on at that stage of the process which patents are valuable. And so when it turns out that patents are valuable, there's going to be litigation to determine which ones really are valid. So there should be a strong presumption that challenging validity and challenging essentiality are positive things that are positive for the public. And it's the idea that they should weigh against willingness or deprive somebody of access to a FRAND rate is really disturbing and harmful to the public.
Right, and that's exactly my point. It's that you can't have a situation where something like that is deemed negotiation behaviors that are used against you. It's just, it should have no place in terms of this conversation.
Just to be clear, when you say let's just unpack exactly what you mean by that. What should have no place in this conversation?
Taking certain positions in the negotiation behavior to explain why you believe a certain rate is fair, as opposed to what your counterparty might think. And for example, me saying, I'm not so sure that some of these patents are even essential to the standard, or I don't believe that that a couple of these patents are even valid. That is a negotiation position or behavior that shouldn't be used against me simply because I am doing something which, as Alex pointed out, at the end of the day, is a good thing. We should all want only valid patents being enforced, right? We should have good patent,
I think,
quality patents out there. So,
I think I agree with the concerns that you're articulating, but I would express a little more sympathy for the agencies and what they were trying to accomplish in the draft statement, right? So what I hear is, we could think of like a European model for adjudicating a FRAND dispute, and they seem to be headed down a path where they really specify the dance, the negotiation. This side has to do this, and then this side has to do that, and then the other side has. And if you deviate from the path, the injunction is back on the table. And I hear you saying that's not a good model, and I agree with that. I think a principle should be sort of what you articulated, Jim, that let's get, in the event of a negotiated breakdown, let's get someone to set a price. There should be a process where a court can adjudicate what's FRAND. Then if you refuse to pay it, we can start to think about, sort of additional incentives that are more draconian. But I think also what the agencies were trying to do is not push us in the European direction as much as articulate what a productive negotiation might look like, sort of how transparent is the information environment? I think they actually even say things like, it's not unwilling to challenge the validity or infringement of these patents, okay? And so pulling in some discussion about what licensing looks like provides them with a way to sort of articulate what productive exchange of views looks like, so as to articulate, hey, that's not unwilling, or that doesn't bring injunction back on the table.
Well, Tim, as your comments in response to everyone else's comments proves, this is a lively and hotly debated issue And I just want to take a moment to say thank you to all of you for giving us your insights and your thoughts from the front lines, truly, of the markets that are most affected by these IP and antitrust debates, both now and in the future. We really, really appreciate your time. We appreciate your insights, and we appreciate your input on all of this. Thank you so much.